because the thrust of today's discussion is that there is a type of retirement plan called a multiple employer plan that brings economy of scales to groups. So I'm going to explain what it is and how it works and give you an opportunity to ask questions. And I think we can afford to be a little bit informal. We do have a little background noise. We may need to remute the phones and then just go ahead and use the chat. But let's try it on off of mute for now. But if you have a question, by all means, just speak out and don't be afraid to interrupt us. So I'm going to start with just a quick introduction. So a little bit about Pentegra first so you can understand where we're coming from. We were founded as a cooperative in 1943 by the Federal Home Loan Banks to create a multiple employer pension plan for their employees. So to put that in perspective, at the early part of the 20th century, there really were no retirement plans to speak of. There were only a handful in the entire United States. And there wasn't a retirement plan industry. There were no actuaries. There were no third-party administrators. There were no vendors. So to try to figure out how to deliver a pension program was a challenging thing. And so the Federal Home Loan Banks banded together so that they could create a program using all of their strengths combined. So that plan, that program, continues to go strong today with hundreds of adopting employers, banks all over the country, and over $3 billion of assets. There's a companion group trust program with $500 million. So collectively about $3.5 billion of assets invested through that program. There's also another companion program, a defined contribution plan, 401k, that has about 1.7 or 1.8 billion. So these are very successful, long-standing programs that were put together as part of a cooperative effort to get economy of scale by joining forces. So where this has led us as a company is to give us the ability to do this for others. So Pentegra is a partner to associations, chambers of commerce, or just groups of employers who want to do something similar, who want to start these types of retirement plans. So let me talk a little bit about what these things actually are. A multiple employer plan is nothing more than a single plan document, a single trust, and you can join your smaller plan to this larger plan and you get a better deal. You get economy of scale, you save time, you save money by sharing the effort and sharing the burdens with other employers. The reason that it works is that there's one plan document. So instead of 100 employers having to each have their own plan document and be the plan sponsor and appoint a trustee, an administrator, an investment fiduciary, an oversight committee that meets regularly, has processes, takes notes, keeps records, all of those things get duplicated 100 times when each employer has to have its own plan. But with the multiple employer plan, you have one plan document, you have a single committee helping oversee the program, so the level of oversight needed locally is very low. You have a single trust, so you're pooling the assets, you're getting access to the lowest price of shares, and you're pooling the administrative effort as well, typically appointing a professional administrator, what we call a 316 administrator. So you get professional management, but because of the group purchasing power, you get it at a discount, and you simplify your efforts greatly. And I'm going to pause for one moment and just make sure that I have the right version up here. All right, I do. My apologies. There was a slide there that should have been deleted and was not. So let me press on and talk about how retirement plans operate, just to give you a flavor. So what does this actually mean? And from a business perspective, if you have an association or a cooperative of any kind and you say, this would really help my members have to spend time on this stuff, and they'd really rather not. They'd rather spend their time in other ways. So what would this look like? Well, a group of them comes together and says, yes, we'd like to be a part of this thing. We'll be co-sponsors of the arrangement, and we'll help form this committee. We'll take turns serving on the board and figure out who's going to do the work so that not all of us have to do the work. The association is in a perfect position to help oversee that. So in many association plans, the association is there for a reason. They're there to help provide benefits to members. And they would typically sit at the center of the thing and help govern it, help ease the burden of the board of directors so the members have as little to do as possible. And in many cases, the association wants to get compensated for that. That is legally permissible. You have to get the governance structure right, and that means figuring out who's going to be the sponsor, who's going to be the administrator, who's going to be the fiduciary, who's going to do what, and making sure you're very careful about who gets paid and to do what services. But fundamentally, if you're an association, you want to provide this for your members, you're going to have work associated with that service that you provide, and most associations would like for that work to be compensated or at least offset in some way. So that is possible. So what this looks like generally is that you put together a program for your members, and you're at the heart of it, and then you figure out these things. Who's going to be the sponsor? Who's going to be the administrator? Who's going to be the fiduciary? These are the main roles in a retirement plan. And the way that they're appointed is that the plan sponsor, through plan document language, appoints an administrator and a trustee. And the administrator and the trustee are the ones who run the plan. They do everything. Sponsor actually does not run the plan. All they do is create the plan and have a plan document to appoint the people to run the plan and to determine how the plan will be run. It's the administrator and the trustee who actually run the plan. So the sponsor doesn't have to do the running. So you have to fill these roles. In a single employer plan, the sponsor is usually the corporation or the entity. The administrator is also usually the entity. And the trustee is usually an individual, typically an owner or senior executive of the company. There might be a committee. And in large enough employers, it will be a bank trustee, but that bank trustee will not accept discretion over investment decisions. The committee or the company still has to control investments and be the investment fiduciary. But the sponsor can outsource all of those things to outside parties, and that is normally the way you would do it in a multiple employer plan. In a multiple employer plan, because this is a member-driven concept, the members need to control the plan. And the best way to do that is through a board of directors. So you have a volunteer board made up of executives of the adopting employers who are taking turns to serve on the board and help with the governance. So your typical way of getting one of these up and running is that you have a handful of members who are enthusiastic about the concept, who are supportive of the association or the overall effort, who not only think this is good for their employees and therefore a good thing for their employees, very important point, but they're willing to help be part of the founding membership and serve on the initial board of directors. So you need to get some yeses. You need to get some members go, yeah, this would be very helpful to us and to our employees. We're in, and yes, we'll help serve on the board. And they typically have questions. They want to know, how much work will it be? Will there be any risk? Is there insurance? What do I have to do? And there are answers to all those questions to walk them through it. They don't have to do much. The risk is extremely limited, and there is insurance, so they're very well protected. So you can answer the frequently asked questions of these early board members. This is a key step, and once you have that board formed, you now have a group of members, a group of adopting employers who control the arrangement, appoint the service providers, and provide a layer of independence and comfort to other adopting employers because they know they have folks like them controlling the plan. Another part of the power of this particular structure, because you don't have to structure a multiple employer plan this way. This is the Pentegra way of structuring a multiple employer plan. We've been doing it for 70 years. Part of the power of it is we know that the Department of Labor is comfortable with it. We know that the Department of Labor likes to see that the employers are in charge of the arrangement. What they don't want to see is that the vendors are in charge of the arrangement. They don't want to feel like this is a marketing gimmick put on by vendors. And they have a long history of not liking that sort of arrangement. They want to see a genuinely member-controlled entity or a program, and you do that best through a board of directors. It's clean. It gives everybody appropriate levels of control and comfort. So what's the benefit of the MEP? Economies of scale are what you get from the multiple employer plan structure, and there are actually dozens of examples of chores that become easier. And if you think about that word chores, it's not a bad word for the work associated with running a retirement plan. You have a plan document, and in that plan document, you have a trustee and administrator. And if you just do a search in that document for the words trustee and administrator, and especially administrator, the administrator is the one responsible for everything other than the assets. The trustee is responsible for the assets. So the word administrator will appear in a typical plan document over 200 times. And each of those 200 times generally represents a to-do item. And some of them are major and some of them are minor. But that's a lot of to-do items. And any one of them individually is not a huge burden, but collectively they can be quite a list. And realistically, our experience is that the employers do not read their own plan documents. They do not establish the kinds of processes they need. They do not put the kind of time into governing the program that would be required to actually complete all of those 288 items. And they certainly don't keep the kind of a fiduciary file that would actually be able to demonstrate that they have processes and have followed them to accomplish the to-do items. So the first type of economy of scale is just simply centralized governance to take care of the to-do list. Instead of 100 employers having to take care of it, how about if you take 85 of those, or 185 of 200 items, and you take care of them centrally? The employers still have to take care of the other 15, but it's a serious reduction in workload. So you only have one plan document. When it has to be amended, there's only one amendment. Normally, you'd have all of the employers would have to do that. Right now, we're in what's called a restatement period. Plan documents under IRS regulations have to be rewritten or restated every 5 or 6 years on a cycle. And when that happens, the charge for updating that document is usually about $1,200 to $2,000 more for a custom document. Instead of that, you just pay only one time for the entire arrangement. You have to pay in a multiple employer plan. Decisions and approvals. There are lots of little decisions that get made in a retirement plan. Phone calls, emails, something has to be approved or signed. That, again, happens at a central level. One of the consequences of this is instead of 100 employers having to have 100 quarterly meetings with 2, 3, 5, 7 people in each meeting, these committee meetings, you can have fewer meetings that don't last as long and have fewer people in them. The documents become more uniform. The platform is uniform, so the administration is a little bit smoother. Documents that get sent. One of the adopting employers, one of the programs we established in 2014, one of the initial board members said, so you mean that the stack of paper that they send me every year that I'm supposed to do something with, and I'm not going to get that stack of paper anymore? And in this case, the answer was, yes, that's right, you're not going to get that stack of paper anymore. He was talking about a series of disclosures and notices and the Form 5500 that has to be signed and reviewed and so on. And yes, that goes away because it's being done at a central level. So single trust, lowest cost shares, you get better purchasing power for things like stable value funds. There are literally dozens of other minor and major ways that the MEP offers economies of scale. But one of the greatest benefits to employers is really that it's just simpler and it's easier. By having less to do, you not only have less to do, you have to devote less brain space to it. We had an employer in the Carolinas in 2012 or 2013. When they came on board, I was really struck by the comment from the CFO. The CFO was a lady who had taken over from the prior CFO, who was extremely experienced and knowledgeable about the retirement plan, understood the plan, had read the plan document. I mean, the old CFO was very conscientious and knowledgeable about running the plans, and therefore very confident in her ability to do so. The new CFO didn't have that experience and didn't have that confidence. And her comment was, I don't even know what I'm supposed to know, but I don't want to know what I'm supposed to know. And I've always remembered that quote. She didn't even want to know what she's supposed to know. That the act of even studying what it is she's supposed to be doing was a distraction to her, and she really didn't want it. And the context in which this was occurring was one in which a chore, one of the 200-some to-do items, a chore that fell to her company, and therefore to her, hadn't been done correctly. And she thought that's what the vendor was there for. how could this have happened? And in this case, it was some obscure stuff. It was spousal consents had not been handled properly. Source coding hadn't been done right, and it affected distributions over a period of years. And she was holding the bag on it. She had to engage an attorney. And her thing was, why am I even having to deal with this? I thought that's what I hired vendors for. So employers want this to be much simpler, much easier, and when it goes wrong, they want somebody else to take care of it and be responsible for it. And multiple employer plan does that very well. So a key concept with the multiple employer plan, a MEP, is outsourcing, that you're, instead of doing all this stuff in-house and replicating the effort, the shared effort effectively outsources a large portion of the labor, of the study involved in learning what you're supposed to do, the headaches associated with problems, and the risk associated with these roles. Something that another client pointed out to me years ago when he became aware that he did not have to be the administrator of his plan. This was a business owner, and he had named his company as the sponsor and the administrator of the plan, and that effectively meant he personally was the administrator and also the trustee. And his comment was, I can't think of a better way to avoid the legal risk of signing this document than not to sign this document. And he was talking about the plan document and the fact that he's appointed in the plan document as the administrator. So the point that stuck with me there from an employer who did not want to be the administrator was, if my name comes off the document as the party legally responsible for this list of 200 items, I'm no longer responsible for those 200 items. That's what I want. And that is what an outsourced administrator does for you. When you hire a professional administrator, the list of to-do items goes down. So we call that type of outsourced administrator a 316 administrator for ERISA Section 316. It's just the definition of the plan administrator. It's usually the sponsor. So why is that? Well, it's because there have not been, in the history of our industry, services to outsource it. In the early days of ERISA, which was passed in 1974, there were third-party administration firms that would take the name third-party administrator and say, well, why wouldn't we be the administrator? And so they would take this role, sign on in the plan document, be named as the plan administrator. That ended very quickly. There was a rapid realization that the role carried a great amount of risk and too little understanding about how the lines are drawn between the employer and the professional administrator. So that died out very quickly, and it really didn't come back in any form until recently. And to a large extent, the way it has existed since before ERISA is in a multiple employer plan. In a multiple employer plan, somebody has to be the administrator. And in many long-standing multiple employer plans, it's a professional firm like Pentegra. So Pentegra has been serving in this role for 70 years. That is where this comes from. So this notion that you can outsource to a professional administrator has really only existed in multiple employer plans. Recently, we in the industry have begun offering it on a standalone basis. You can hire today a professional administrator, but very few firms are experienced at it. But it's, as I've mentioned before, a service that gives you some peace of mind and saves you some time. If you think about what kind of time that you save, what would you spend your time on if you're the fiduciary of a retirement plan and you care about doing it right? And I say that because some clients don't care. Some of them, you could say, well, gee, the Department of Labor rules say this and the IRS rules say that. They're like, yeah, I don't care about that. I've never seen an auditor. I've never heard of anybody getting in trouble. I don't care. I just want it to be cheap, and I'm not going to do anything with it. Those folks are out there. They'll always be out there. They're probably the ones most likely to get in trouble. But those are not the ones who are going to gravitate to this sort of solution. It's the ones who do care and are spending time on this stuff who benefit the most because they are not having to do a lot of these things. They're not having to study what the rules are, to read their own plan document, to figure out, as an example, that there are multiple ways of handling hardship distributions, for example, and you have to read your own document to figure which method you're using in your plan and make sure you have a process for it. Because the vendor will only handle portions of these tasks. That's part of the problem, is there are things that come back to the employer all the time. And the whole point is, how do we get those things off the plate of the employer? So this list is an example of some of those things that people spend time on. Another question that comes up in this regard, along the lines of the employers who simply don't care. Why don't they care? Well, part of it is a perception that they don't have any risk, that the risk is remote. And the reality is the risk is far from remote. There is the risk of getting sued over a problem in a 401k is in fact remote. But the lawsuits do not tell the story. So if you look at the statistics and surprises on this page, the bottom line there is the lawsuits, 8,800 ERISA lawsuits. But the reality is most of those lawsuits, about 80%, were for health care. And of the 20% remaining, most of the remaining retirement plan lawsuits had to do with defined benefit plans. And they had to do with benefit claims. They had to do with the type of thing Pentegras had to deal with for decades, which is a spouse of a deceased member of our plan wants a full retirement benefit, not the plan's mandated pre-retirement death benefit, and is willing to go to court to try to get that full benefit, even though the plan document says she's not entitled to it. That's a real lawsuit that we had to take care of. That sort of thing doesn't happen often, and like I said, when it does, it's mostly defined benefit. So how you get in trouble is not lawsuits. Lawsuits are rare, and they tend to focus on certain things. The problem is all administrative. It is in what seem like minor peccadillos, things that go wrong, and they result in what's called a voluntary correction program, or VCP filing, where it results in a DOL investigation. And when DOL has investigations, they virtually all, not always, 75% of the time, they are collecting checks. That $397,000 average you see on the screen is misleading. For a small employer, it's a much smaller number, so averages can be deceiving. But 75% of the time that the DOL does an investigation, they force the employer to write a check. So this is out of 650,000 retirement plans in existence in the U.S. These are some fairly high numbers. So the notion that nothing ever goes wrong is certainly not true. It may never have gone wrong to a given employer, but most intuitively understand that this stuff is tricky and can get them in trouble. Another one of my favorite ways of explaining the benefits of this is that the IRS keeps this list of most common voluntary correction program, or VCP filings, and you can get this right off their website. They used to call it the top 10 list. You won't find it under that anymore. And the very first one is one of my favorites, failure to amend the plan document for tax law changes. Virtually every employer in the U.S. who has a retirement plan has a third-party administrator or record keeper whose job it is to get this done for them. And yet, it is the #1 most common VCP filing in the United States. Why is that? And the answer is because the burden of actually completing the action falls to the employer. And some portion of the time, the TPA screws it up, but a lot of the time, it's just that the employer doesn't get it done. They had a role to play, and they didn't play it. It sat on their desk. They didn't send it. They didn't sign it. And I could go down the list here, but these are all things that happen routinely that are preventable, and they are much more likely to be prevented when the employer is not the fiduciary. One of the questions that arises in connection with multiple employer plans is the money safe? And when you have professional fiduciary oversight, it's arguably much safer. But one of the safety measures we believe in is that an institutional fiduciary provides safeguards that no non-institutional fiduciary could provide. And what we mean by that, institutional means a bank or trust company that is the trustee and or administrator. So when you give access to your employees' money to a third party, you need confidence that that third party is a safe place to put money. And there's no safer place in the U.S. than the bank and trust system. And I sometimes people question this, and they point to things like 2008 or 1929. But the track record of asset safety in the banking system in the U.S. is unparalleled. The money doesn't go missing. When it does, they track it down. There have been so few cases of fraud and abuse, and there are many safeguards in place to protect banks and trust companies have to have reserves and insurance and dual controls and segregation of duties and audits and regulations. And when you hire an individual or an LLC or an advisory firm or someone else to take these roles, you just don't have those protections. So an institutional fiduciary is safe. So to sum up the benefits of a multiple employer plan, you get to outsource a lot of the work, a lot of the headaches, a lot of the risk of running a retirement plan. It makes it simpler, easier to run the plan, and that costs money. So when you pay someone like Integra to do this stuff, there is a fee for it. But when you're doing it in a multiple employer plan, you can do it for less. It is the most affordable way to have professional management of a retirement plan. So again, here are some of the things that you get in the structure with a single document and the one large trust. And that leads us to what sorts of decisions an association, a cooperative, or a group of employers might need to make. And one of those questions is, should we do this? Is this a benefit to our members or not? So let me speak to that for a second, because this does not fit every group of employers. But there's a pretty wide array of types of groups that it might fit. But the number one characteristic is there has to be a critical mass of employers who are large enough to have a retirement plan. So if the problem that the association is seeking to solve is that retirement plans in general are too expensive and very small employers with 1 or 2 or 3 employees cannot afford a 401k, a multiple employer plan will help with that problem, but it will not solve it. Unfortunately, that is something structural, that these plans have a lot of compliance, they have a lot of infrastructure, they require a lot of oversight. They're not cheap to operate. It costs several $1,000s, and even though that's not a lot in the grand scheme of things, a small employer doesn't pay it. So there are 6 million businesses in the U.S., but only 650,000 retirement plans. So a multiple employer plan won't cure that problem. So an association whose membership is very, very small employers who do not have retirement plans, and the problem they're seeking to solve is to give them a cheap retirement plan where before they had none. Unfortunately, this will not solve that problem. It'll do it better than anything else out there, won't solve the problem. Another type of group that it might not work for is huge organizations. So an association or a group of huge companies. What's the benefit there? Well, those huge companies can get these outsourcing benefits to a degree on their own. They have enough assets to pay for all kinds of help. So the benefit to them is much more modest, and the cost savings is likely much more modest as well. So there would still be benefits to large employers, but they're not the ideal group. So the first question with building it is this even, does our membership fit? But if you have a membership where a significant number, a critical mass, do have retirement plans, yes, there's probably a good fit here. Another question is the program structure. So again, speaking to someone who is at the association level, not at the adopting employer level, the association might want to sponsor the plan. They might want to get compensated. They might like the idea of this as a benefit to members, but they really want their name on it. Well, what we would suggest there is we talk you through the various governance structures, because if you want to be compensated, you should not be the sponsor. You should let your board of adopting employers sponsor the plan and be in control of it, and appoint the association as a service provider, helping serve as the primary liaison with other service providers and fiduciaries, helping organize board meetings, and generally be the glue that holds the program together. That is a worthwhile, necessary role for which compensation from an ERISA retirement plan is appropriate. And that's a sound basis for an association to receive compensation. But if that association is to sponsor the program and controls the appointment of the fiduciaries who choose whom to pay, well, now you have a conflict, because you essentially have the power to appoint yourself and pay yourself, and that is not allowed. So we have a structure that makes sense, that helps keep it independent and conflict-free, and also allows the association to get paid. So the big decision there is, does the entity or the group want to sponsor the thing as a benefit for free and contribute their labor for free, or help with the creation of a program that they will serve for some modest or appropriate compensation. That's the biggest structural decision. You have a decision to make about service providers who will serve. So you need a record keeper, an administrator. You need a trustee, an investment fiduciary, and there are a number of ways to appoint fiduciaries or outside entities to do these things. The responsibilities that attach to each role, so the division of labor, will you hire a fiduciary or a non-fiduciary service provider? Are you going to want service at the adopting employer level? Do you want education and work for the employees? There are ways of working through that. So these are some of the decisions to be made in the structuring of the program. But fundamentally, to summarize the benefits of this, why would you want to start such a program, and why would you want to join one? And the answer is that it's simpler, it's safer, and it costs less to deliver these benefits. It's simpler because instead of sponsoring your own plan, having your own document, and duplicating all this effort, you share the work through a board of directors and you delegate to professional fiduciaries. And through that delegation, there is a genuine transfer of legal responsibility and liability. There's a quote from ERISA Section 405C that says, you shall not be liable for the acts and omissions of a fiduciary to whom you have allocated or delegated a particular responsibility. You're not responsible for their acts and omissions. So that transfer of responsibility makes you safer. Also, in the programs that Pentegra structures, we include an insurance component so that the level of protection for all of the fiduciaries, including all of the adopting employers, is typically higher than any of them has individually. And this is all possible at a much lower cost because of the pooling of assets. The purchasing power of many is much greater than the purchasing power of any one of them alone. So with that, I'm going to pause and open up and see if there are any questions.
Thanks, Pete. Appreciate that. Very enlightening. Let's see, we've got a couple typed in questions here. Let's see here. The first one is, if I change my plan from a single employer to a multiple employer plan, do I still have fiduciary duties, or have all the duties been outsourced to the MEP?
So there's one basic rule about being a fiduciary is that if you're making a decision on behalf of someone else, then you have a responsibility to that other party as a fiduciary. So the decision you make when you decide to join a multiple employer plan is you're deciding that this is a good thing, an appropriate thing for your employees. That is a fiduciary decision. So having decided that, you do have a duty to make sure that it's a prudent decision and that it remains a prudent decision. So you can't just ignore it. You do have to do a little bit of oversight. But the level of oversight needed in this environment is dramatically less. But you're still a fiduciary for certain purposes, and that's one of them. And another would be, as an example, you're holding plan assets every time you deduct money from your employee's paycheck. The law says that when you do that payroll deduction for a 401k, you're holding plan assets, and that makes you a fiduciary. And you have to give that money to the trust as soon as you practically can, which in reality is a few days. So you have the fiduciary duty to forward contributions when they are owed. And you also are the only party who knows your employees. So you have to let the other fiduciaries know about new hires and terminations and payroll data and other points of information about your company and your employees so that those appointed fiduciaries can do their work. But other than those three duties, selecting and monitoring the arrangement, making sure it's a prudent choice, not a difficult one. Data, providing data to the providers, and contributions, everything else can be outsourced to the multiple employer plan.
Great. Again, we are unmuted, so if any of the attendees have any questions, I invite you to speak up right now, and Pete will be able to answer that question. Otherwise, we do have a few more that we can get to.
All right. Well, this is Mike Natashak, and Pete, again, thank you so much for your presentation, and I look forward certainly to working with NCEA members that are interested in this type of program. I have a question for you, Pete. One of the, and it's a popular question I get when we talk about this, is a multiple employer plan a one-size-fit-all type of program? In other words, if I join this type of arrangement, do I lose the ability to set my own vesting schedule or my own age of entry level, or can I customize within the MEP?
You can customize to a great extent. The nature of the MEP is streamlining, so you do have fewer choices than you would have in a single employer plan, because that is the entire point of it. So as an example, there's going to be a shared fund menu. Everybody's going to be using all the funds. So, you know, if you work for a company that has 100,000 employees and you participate in that company's 401k, all 100,000 employees use the same fund menu. We're going to do the same thing in the multiple employer plan. We're trying to recreate the purchasing power of those 100,000 employees, so everybody's going to share the same fund menu. So if you want to come into the MEP, but you want to choose your own funds for your employees, well, don't go in the MEP. It's not for you. The thing that most employers want to control is who gets in the plan and when, and how much money do they get and when. Those things are all controlled at the local employer level. So in the multiple employer plans, the Pentegra structures, because this isn't universally true of all MEPs, you have almost total control over who gets what money when and who's allowed into the plan when, and you have a lot of design flexibility. But the board of directors gets to choose, hey, which options are available. Generally, we see the boards leave it wide open. But there are certain things that you cannot do in some multiple employer plans. So an example would be some companies want to offer employer stock. Well, you're not a candidate for a MEP for the most part. You might want to do some very unusual testing with a tiered match based on eligibility and a couple other factors. Those match formulas are rare these days. Most MEPs do not allow them. So we have found that fewer than 5% of employers select out of the MEP based on plan design reasons, but there are absolutely limitations. They are modest. You get to control the things that matter most, but it is a streamlined arrangement.
Thank you.
Great.
And I think I see there's one other question here online, or a couple more questions that I can hit. One of them is that there's something called a bad apple rule. So what is this bad apple rule that can disqualify the plan? And is that true? Is there such a rule? Yes, there is. We call it the one bad apple rule because the nature of it is if there is a qualification failure by any one of the adopting employers, that it would disqualify the entire plan. So when we say it that way, it sounds very scary. It is a rule. It's in a Treasury regulation. But the reality is qualification failures happen every year to most plans. And a simple example is the ADP test, average deferral percentage. That's the test that says that your highly compensated employees are only allowed to put in so much money based on how much the non-highly compensated put in. And it's very common for employers to, quote, fail this test. Well, it doesn't disqualify the plan unless you fail to fix it. So for all of these tests, there are corrections, and you don't handle problems by disqualifying plans. You fix the problem. The only plans that get disqualified in the U.S. are abusive tax shelters for, you know, very wealthy small businesses who are doing things they really, really shouldn't. That's a fair generalization. So answer number one to the one bad apple rule is there are easy ways to correct these things. Answer number two, in the preamble to that Treasury regulation, the IRS specifically says that an offending employer who doesn't make appropriate correction can be spun out of the MEP. And point number three is that Pentegra's been doing this 70 years and never had a problem with this. We really view it as a non-issue. But it's a real rule, and it's a legitimate question, and we encourage people to draw their own conclusions about it.
Great. And I think there was one more in there, Pete. I guess kind of a general question. They sound like a great way to go. Why isn't every qualified plan an MEP?
Well, that's a softball, I guess. There's a history here. And historically, these things have been run by groups like Pentegra for like-minded employers like financial institutions or members of an association. So there's this handful of kind of old-line multiple employer plans out there. The notion of broadening this and creating new programs is relatively recent. And we are finding that there is a significant surge in interest in these programs and has been for a number of years. We think we're at the beginning of a very rapid acceleration in the growth and popularity of multiple employer plans. But they will never take over the market completely, in our opinion. There will always be a place for customized single employer plans, so that 5% of employers who want a custom, some kind of provision that cannot otherwise be taken care of. That sort of thing will always be around, and there will always be companies who have employer stock. There will always be companies where it's a group of doctors and they want to do their own custom investments. So we think that we're on a period of rapid growth in interest in multiple employer plans, and they could very well become the dominant method of delivering these things, with we think the likelihood that they will never completely take over.
Right on. Well, it looks like the end of the chat questions. If there's any other questions, we're happy to answer those. Otherwise, Pete and Mike, is there anything else that you guys would want to add before we wrap things up here?
No, I thank everybody for participating, and if you'd like to learn more, please reach out to us.
Great, absolutely. Well, again, NCBA CLUSA thanks Pentegra for their time today. We thank all the attendees for joining us on this webinar. Again, we'll be circling back with everybody and sending around the recorded link, so you have that. And please stay tuned to the CBJ online. We've got some great things to announce in the coming weeks. So if you're not subscribed to the e-newsletter, please head over to the website and get that taken care of. Again, thank you to Pete and Mike. We look forward to some great collaborations in 2015. And again, everybody have a great rest of your week. Thanks again for participating today. We'll talk to you all soon.